Hi, everybody. Thank you for attending your Know Your Rights training for business owners and employers. Today's training is hosted by Seattle Office of Immigrant and Refugee Affairs and Seattle Office of Economic Development. My name is Gina Yang, and I'm the Workforce Program and Policy Specialist at the Office of Immigrant and Refugee Affairs. I'll be your MC for the day. For today's agenda, we'll first share information and resources from Seattle Office of Immigrant and Refugee Affairs, Seattle Office of Economic Development, presented by small business advocate Michael Wells, and the national organization American Business Immigration Coalition, presented by campaign director Michael Dager. This will be for business owners who need more assistance. Please feel free to reach out to them after the training. Finally, a presentation from our main speaker, Diane Butler from Davis Wright Tremaine. She'll be covering 4 topics: handling ICE and other immigration encounters, handling Form I-9 audits, Social Security no-match letters, and best practices for employers. We'll answer questions after each section. This training is open to the public, so please be aware, and it will be recorded as well. So please do not share any personal and sensitive information. Throughout the training, if you have a question, please click Q&A on the top menu and submit your question in the box. Quick introduction of Office of Immigrant and Refugee Affairs, also known as OIRA. Were established with Seattle being the leading city in Washington State on immigrant integration. We established in 2012 with 3 staff members. Currently, we have 12 staff. The office mission is to improve the lives of immigrant and refugee residents in Seattle. We do not provide direct services, but work across city departments, including mayor's office, and collaborate with community-based organizations. Our programs are based on immigrant integration spectrum, from entering to the United States, becoming a lawful permanent resident and U.S. citizen, to becoming a leader in the community. We have programs such as Legal Defense Network and New Citizen Program, where they provide legal services and citizenship classes. The program that I manage is Ready to Work, which provides English classes with job skills training and employment support services to those who are looking for work. We also provide outreach to immigrant and refugee communities through our ethnic media and immigrant refugee commissions, while advocating for local and federal policies. Lastly, we are the hub for language access, supporting city departments with accessibility. Seattle is a welcoming city to all residents. Seattle City does not ask about immigration status and serve everyone regardless of status. City of Seattle also does not cooperate with immigration enforcement, but does not prevent or impede it. For your information, immigration enforcement is a federal matter. Now we will have Michael Wells, small business advocate from the Office of Economic Development, to share about their business support programs.
Hi, folks. I'm Michael Wells with the Office of Economic Development. We sometimes refer to that as OED. And I'm joined today by my colleague, Kat Durning, who is our small business navigator for resources within the city. I'll be telling you a little bit about our programs, a couple of programs that are relevant so that you can use those for further access. There's Kat. Hello, Kat. And we'll have our contact information at the end. So briefly, we want to tell you about some of the programs that we have to offer at the Office of Economic Development. Our small business support programs fall under our small business division, which includes our small business navigation team, our wealth creation team, and our capacity building team, which is our neighborhood business districts and business supporting organization team. So Kat and I work directly with small businesses one-on-one, and we're happy to answer any questions and be a resource for you for any further questions. The next slide, please. You'll see our small but diligent team. We currently have 4 members: Philip Sitt, our manager, Kat, myself, and Eduardo Rojas, another small business advocate. Soon we'll have 2 extra staff members, and we'll have a more robust team to be able to serve small businesses across the city of Seattle. And we'll provide contact information a little later in our presentation. Next slide, please. So general eligibility to participate in our program. So here are the standards for participation in any of the programs I'm about to describe. So number 1 is having this valid City of Seattle business license. And if you don't have that license, we can help you get that license and put you in touch with the people at the city and the state to get the licenses. The Seattle business license is a city function, and we can connect you to the correct people if you don't have that on hand. We support businesses within the city limits. We work with a lot of partners that support a broader geography, but our programs are designed specifically for Seattle residents. And you must be a for-profit or independent non-franchise business for the small business services. We do serve nonprofits as well, but the priority is for-profit businesses and independent non-franchises business. The definition of small business is broad and varies across federal, state, and city agencies. The Small Business Administration defines that as under 500 employees. We find that most of the people we're serving have under 50 or even 10 employees. And just to be aware, many of our programs prioritize women and minority-owned businesses, but services are open and available to all. And OED never asks about immigration status in any of our service provided. And we offer translation and interpretive services. At the bottom of that slide, you'll see a blue box with our phone and email address, which is what Kat is in charge of responding to. Services are available in Amharic, Chinese, Korean, Somali, Spanish, Thai, Vietnamese, and many more languages. We work with both our partners at the Office of Immigrant and Refugee Affairs, and we work with Lake City Collective for interpretive services as well. So we have options for language access for anyone that needs it. Next slide, please. So the primary reason I'm here today is to talk to you about the accounting and business consulting program that we have offered through our office. My colleague Robin Duquette manages that program. The Accounting Business Consulting, or ABC program, is really ideal for Seattle-based businesses and nonprofits that want to grow. Each eligible business receives up to 10 free hours of one-on-one consulting. So we have a roster currently of 10 small business consultants. We're adding 6 more to those. That will make 16 total in the next 30 days. And they can offer consulting on these buckets that we see here: accounting and bookkeeping, marketing and branding, business development, credit and debt management, loan support. And within those, there are many different avenues. Business development could include anything from a business plan to an employee labor manual or understanding labor ordinances, but those are free services. And each of those buckets includes the 10-hour maximum free service. So you can take advantage of the program up to 40 hours if you'd like to work with all of those programs. And you'll see some of the consultants we work with as well. Again, the roster will be increasing this coming month, and our office can always provide that full roster base. Next slide. And the Small Business Legal Program is the program that I manage. Small Business Legal was created during the beginning of COVID, and we had worked on some legal products for small businesses previously, but we created that program coming out of COVID, realizing there was a need for small businesses to be able to manage the complex legal landscape and relationships and language within the legal small business intersections. So our program offers free consultation to address legal issues associated with owning and operating a small business. We have free one-on-one consulting services and workshops, including individual consultation with legal professionals, corporate and intellectual property education, commercial leasing, landlord and tenant resources and education, business-specific legal reference materials, and legal workshop and resource development on issues such as commercial leasing, intellectual property, employee labor relations, etc. So those are the 2 programs we wanted to focus on today, make sure that you folks were aware of. I think our contact information is on the next slide. Kat or myself would be happy to help you at any time, but this is the best way to reach us, and then we can point you in the direction of the services that you're looking for. We are available for service to all small businesses in Seattle, and That's our presentation. That's who Office of Economic Development is, and we hope to talk to you in the future. Thank you very much. We appreciate our partners and the lawyers who are working on this important training. So have a good day.
Thank you so much, Michael. Now we will have Michael Dager from American Business Immigration Coalition and sharing about their organization.
Hi, everybody. I'm going to go ahead and share my slides. Share screen. Usually I use Zoom, so give me a sec. All right. Hi, everybody. So I am a campaign director with the American Business Immigration Coalition. And essentially, we are a bipartisan coalition of around 1,700 employers in a couple dozen states advancing common sense policy on immigration and workforce that both ensures that employers have my kid's pediatrician just called that employers have access to the talent that they need, and that we're growing our economy and ensuring that immigrants can be fully integrated into our communities as workers, as consumers, as taxpayers. And in this moment, we're really focused on how can we respond and move forward solutions given the workforce crisis across essentially every single industry. And I'm guessing, including the people on this call, it's hard to find the folks we need to create to fill essential positions across hospitality, construction, healthcare, ag, manufacturing, et cetera, et cetera. And hard to expand operations, hard to keep the doors open, hard to create new opportunities for native born workers as well. And that's where we come in. We think it's possible to figure out solutions, including in this climate, that both secure the border and secure the workforce that we need. And a big part of our approach is a real focus on bipartisan leadership. So if you look at our board, and I'll send information later on, donor class types from both sides of the aisle, and our network is composed of a really broad array of folks, anything from the Kansas Livestock Association to the Illinois Restaurant Association, to Chandler Construction in Arizona, to just really good mix of folks who can make the case on what does it mean for our economy if we fail to address the issues around workforce, or if even worse, we destabilize the issues around workforce, but also what's the opportunity for any elected official or party if they can actually like take the lead on this. So this is a bit overrepresented Texas pictures actually in here. We do have people in other states as well, but that's just a few examples of some of the recent work that we've done. That one there in front of the Capitol is with Democratic Representative Tom Suozzi of Long Island and Republican Representative Brian Fitzpatrick of Pennsylvania. And then that's two of our board members, Don Graham, who's the former publisher for the Washington Post, and on the right, Andrew Tisch, who's the co-chairman of Lowe's Corporation. Recently, so we just got back from DC 2 weeks ago. And I don't know if I can zoom in here. I guess I can't. But we just got back from DC for the Secure America's Workforce fly-in. We had 121 meetings on the Hill, 45 of those with members directly, not their staff. 73 of those looks like were with Republicans, 48 with Democrats. And we feel like there's a real opportunity at this moment, and it's backed up with polling that we did with Speaker Mike Johnson's, one of his go-to pollsters, demonstrating that the American public, and that's across the general electorate, Latino voters, Republican primary voters, believes we can walk and chew gum at the same time. We can secure the border and we can figure out solutions for people who've been in this country for years, working, paying taxes, not committing crimes, dreamers, essential workers, farm workers, and that's necessary because of the economy. It's also necessary from just a point of view of fairness, and that's across the board. And so we think there's a real possibility here to move something forward and engage with this administration and with this Congress. And you can see some of the folks who engage in our fly-in here with some quotes. I'm happy to send these slides coming out of it. And what we invite employers around the country to do is to work with us in engaging the public conversation and connecting the dots for electeds and for the American public on what does it mean if we fail to address these issues, and what's the opportunity if we succeed in addressing these issues from a standpoint of lowering prices, of American competitiveness, of protecting employers and communities. And so these are just like a very small snapshots of recent coverage of some of our folks. And so everything comes down to, is there a base of employers across sectors working together? That is absolutely core to our model. So we are always looking for new partners who want to share your story publicly or who want to engage in a more private way, engaging with legislators. So we're very, very eager to connect with any of you on this call who want to get involved. And there's a few places for folks to do that. We're establishing councils by sector. This is actually a new thing for us. We're in very beginning stages around launching a construction council, hospitality, ag, healthcare. And we are going to be, for the next 6-7 months, engaging in a whole lot of activities around the country, leading us to before we head back to DC in October. And so I'll share my contact information. These are a couple of our leaders here, Sam Sanchez, who's on the board of the National Restaurant Association, and Matthew Villarreal, who's a tech CEO from out of Texas, who are our leader, Comité de Cien of Latino business leaders. So very good to connect. I will share my direct info in the chat and our website, and look forward to being in touch. And that's it.
Thank you. Thank you, Michael. I appreciate your presentation. And then we'll share your contact information to the attendees after the training. So now for our main speaker, Diane Butler will present and provide information for business owners and employers. Please be aware that this training is open to the public and will be recorded. So please do not share any personal and sensitive information. Throughout the training, if you have any questions, please click Q&A on the top menu and submit your question in the box. We will answer them during the Q&A section. So let's welcome Diane.
Hello, happy to be here and to share this information with you. We're going to be together for a while, so please stick with us through the end. Pay attention to any issues that come up. If you happen to see any breaking news while we are doing the presentation, then feel free to share it with me and I'll see if I can address it as we go along, because as we know, there is a lot going on in the immigration world. In fact, we're confronting such a rapidly changing landscape with the second Trump administration. During the first administration, there were over 1,000 changes to immigration law and policy, and I doubt it will take very long for us to get to the point where there are at least that many. We've got some resources for you, and I think they will be sent out to all of the registrants after the program. We've got a 2-pager on some guidance for developing some procedures and policies for handling visits from immigration enforcement officials. We have some samples of the documents we're going to show you, things like warrants and a sample of an I-9 audit letter. And there also are other resources available from some organizations that I'm quite involved in. The American Immigration Lawyers Association, AILA, has quite a bit of resources available to the public. And I'm also a member of the Federal Bar Association, which is a nonprofit and also a nonpartisan organization that has a very active immigration committee. So those are 2 resources for some additional information. Now we're going to focus on, as Gina mentioned, 4 main topics of this changing immigration landscape. We're going to talk first about what seems to be quite top of mind for many employers and business owners, and that is handling ICE encounters and encounters with other immigration officials. We're going to talk about Form I-9 audits, because there are a couple of seemingly innocuous but pretty important changes that have come up recently for compliance with the I-9 requirements. We'll talk a little bit about Social Security no-match letters, because I know many employers and business owners are concerned about that topic and the implications. And then We'll wrap it up with some best practices for strategies, primarily for your employees, but also for your businesses overall. So first of all, we're going to talk about handling visits from ICE and about other immigration encounters. And I like to call them encounters because that's the word that the immigration officials are starting to use these days. And these are probably, this may seem like what you already know, but just a reminder about some of the key objectives for you as a business owner or employer. And that is you need to be prepared, have a strategy in place, and minimize the intrusion to your business. And we're going to give you some tools for that, because what we're finding are the main concerns for businesses are that if there is an ICE visit, it's not a presumption that you have done anything wrong, but it will be disruptive and it's going to feel probably quite intrusive, and it can be kind of intimidating, but it can also be insensitive to your objective as a business owner to run your business. And I really appreciate the presentations from the Office of Economic Development and the American Business Immigration Council for their viewpoints in helping you as business owners and employers. Okay, first of all, we want to start with the who. Who might be showing up? Now, there are several agencies under the Department of Homeland Security. That's the big umbrella department that has these sub-agencies underneath. And the one that we talk about most is ICE. That is Immigration and Customs Enforcement. And ICE actually has several different roles that they play. One of the roles actually is to oversee foreign students and their compliance with the requirements to maintain their student status in the United States. But another is the one that we are quite familiar with, and that is to be engaged in enforcement in terms of locating those individuals or businesses also as well, who are presumed to have not complied with the United States immigration laws. So to some extent, we'll be using just that acronym ICE when we talk about enforcement agencies and their roles altogether. But I want you to be aware that there are these other sub-agencies under the Department of Homeland Security. One is Homeland Security Investigations, HSI. That is the agency that is responsible primarily for I-9 audits. But we've been hearing recently that HSI has also been engaged in more ICE enforcement actions. I'll be getting into some examples later on about some companies and employers that have had some of these enforcement actions exacted upon them recently. And then there also is ERO, Enforcement and Removal Operations, which works concurrently with ICE in order to locate the individuals who they think need to be placed into removal proceedings or deported from the United States. And then there also is U.S. Citizenship and Immigration Services. That is, many of you familiar with USCIS. That is the agency responsible for what we call benefits. So if any of you are employers who have sponsored an individual in H-1B status or done an employment-based green card, then it is USCIS to which you submit your petitions or applications. They do have some responsibility for enforcement actions, but it's primarily in the nature of an administrative audit. But these are some of the agencies we'll be talking about. In addition, the other who you might encounter includes maybe local police or sheriff's offices, which, as Gina mentioned, unlike what Gina mentioned in King County and Seattle, our officers are not engaged in assisting ICE with their activities. But you also might see some folks who have insignia from the FBI or the DEA, Drug Enforcement Agency. As you can see in this photo here, ATF, Alcohol, Tobacco, and Firearms. and possibly even the U.S. Marshal Service. I coincidentally have a friend who's in the Marshal Service, and he did disclose to me that some time ago they had been asked to engage in some of the ICE activities, but recently there's been, for some reason, some pullback on the marshals actually helping with these activities. And the Marshal Service is primarily, one of their key duties is to protect the judges when they are in public. So I imagine they are probably pretty busy with protecting judges these days. Now, so I'm sure you've seen many of the photos where individuals are wearing, as you can see in this one, the vest that either say ICE or police or any of these other acronyms that we're seeing here. But we also are hearing that there are many instances in which there is no insignia at all. In fact, you may have seen some of the videos recently for unidentified individuals who are wearing hoodies or plain clothes. If they are in fact federal agents, they must have some type of identification on them. We've been hearing sometimes that they have a badge at the waist, but many times the individuals who are encountered are too shocked, stunned, scared, or intimidated to ask for any type of evidence of which agency these folks work for. But that is one bit of advice that we have for you, that when they show up, you really should be asking who they are, why they are here, and with that sort of information, you can at least figure out how to continue on and approach the situation. We also are hearing about a couple of other agencies that are starting to become involved. The Internal Revenue Service, yes, the IRS. They have a criminal investigations division, and we know that the head of Department of Homeland Security has asked the IRS to start becoming involved in investigations. Now, if the IRS shows up, I want you to make sure that you take it very seriously, because the idea there is that they're not necessarily looking at individuals, but they may be looking at your business to come up with some sort of claim that your business is profiting from employing unauthorized workers and therefore not paying the taxes that you should pay. Another agency we'll talk about a little bit more, Social Security Administration. Honestly, they have not been as involved as some of the other agencies. You might feel a bit surprised about that, but we'll discuss that a little bit more, and in terms of how to address a Social Security no match letter if you should receive that. Okay, so what happens if any of these agencies show up? Well, first of all, you should have a plan in place. And again, the first point is to find out who is there, to observe the identity and verify it if possible. You want to ask for a badge, a business card, other documentation. You want to make a copy of these documents. And part of the reason that you want to ask all these questions is to slow the process down, is to take control to the extent possible. And you might even want to practice this a little bit. You can do it on your own. Just, imagine somebody's coming up, do it while you're looking in the mirror, or do it with someone that you work with, just to ask, if they approach and they are very heavy-handed, just ask, you can ask it politely. May I know who you are? What is your name? What agency are you with? Can I see your identity? We understand you have a job to do. We want to make sure that you and only you are doing your job, and there is not somebody who is pretending to be you. So that's our first advice for you. Slow it down, ask questions. Throughout the process, ask questions. I have found in the past, when I have encountered law enforcement officials, if you just start with, can I ask you a question? That gives yourself some pause, it gives them some pause. What are they going to say? No, you can't ask a question. So think about that when you have any sort of law enforcement you are encountering. All right, next we want to talk about what paperwork to expect. And I'm sure many of you have been hearing about warrants, about the warrants that ICE might present, about you may have thought in the past about you've heard about arrest warrants and search warrants. One concept I want you to maybe think about is that we have this notion, I think many of us have this notion about law enforcement from watching TV, where, you know, there's some officer who bangs on the door and says, "Police, open up." And that is, again, a very intimidating approach for somebody to take. And the intention is to make an individual feel intimidated and to comply with whatever the law enforcement officer wants from you. First word of caution, do not consent. Do not do more than you need to do. The law enforcement officers generally would like you to do their work for them. And sometimes they like to take shortcuts and not do the work that they need to do to comply with our constitutional laws, our federal laws, our state laws. So when we talk about warrants, I want to make sure you are aware of one of those shortcuts that is being taken. And that is that ICE and Homeland Security and the other related agencies has a type of warrant called an administrative warrant that they can issue themselves. You can see at the top here, it says U.S. Department of Homeland Security, and it is addressed to any immigration officer. And this one is, as you see it there, warrant for arrest of an alien. So this is, I mean, they can fill it out themselves in the back of their van and then present it to you and make you feel like you are compelled to comply with giving the information. But these administrative warrants, this one is a Form I-200, it says it right at the bottom there, it's not a warrant that you need to comply with. It's not, look here, it's not going to be addressed to you. It's only going to be addressed to any immigration officer. So if you are handed this administrative arrest warrant, you do not need to, and they might say, you know, tell me where whoever it is who is named on here. You do not need to do anything. You may hand it back to the officer and say, this does not ask me to do anything. Now, as we go through this guidance, there are certain levels of recommendations or options for communication that I'm going to suggest to you. But I know that when you get in the moment, it might feel extremely intrusive and intimidating. And so you may you may decide to take another route. If you end up taking another course of action other than what is recommended, you know, just try to remember at least to say, I object. I object. You know, if you feel if you're handed an administrative warrant and you don't want to comply with it, then at least try to remember to say, I object. Because later on you might be able to make a case that this information was provided to whoever's demanding it without the proper authorization. There is another type of administrative warrant, again, issued by Department of Homeland Security and ICE. And this is, the form is I-205, warrant for removal or deportation. And just the same as the arrest warrant. You do not need to comply with this. It's not addressed to you. It doesn't tell you to do anything. And now, so there are other, the type of warrant that you do need to pay attention to is a judicial warrant. So a judicial warrant, here's the difference. At the top, you can see this is issued by United States District Court. And it is going to be signed down here. See where the little blue box is? It's going to be signed here by a U.S. District Court judge or a U.S. magistrate judge. Now, you might think a magistrate judge does not have as much authority as a full district court judge, but they do. In fact, it's usually magistrate judges who are on duty to issue these judicial warrants. So magistrate judge has full effect and force of law to issue a warrant. But here is a key difference between this judicial warrant and those administrative warrants that we were just taking a look at. These to get a judicial warrant, someone like an ICE officer has to go before this judge and say, I think there is probable cause to believe that a federal law was violated. And so, Judge, I need you to help me to enforce the law by issuing this warrant. Now, this one is an arrest warrant. And again, I want you to note here that it is to any authorized law enforcement officer. This is never going to be addressed to you. It's never going to be addressed to a business, never going to be addressed to any individual. It is only addressed to a law enforcement officer. So again, to some extent, you could say, this doesn't tell me to do anything. I giving it back to you. I understand a judge says that you need to do something with this, but basically, I'm not here to help you. I'm not here to do your job. Now, if you receive a warrant, if you are handed a warrant, you cannot impede, you cannot lie to anyone, you cannot say anything but the truth, or state your right to remain silent when there is this judicial warrant that is presented to you. And if it's an arrest warrant, it will list the name of a person on there. So now, the ICE officer who presents it to you may ask you a few questions if they're coming to your place of business. They may ask you, does this individual work here? If you know that they work here, you can't say, I don't know. They might ask, is this person here now? If you know that they are there, then you can't say no. If you don't know, you can say, I don't know. But you can always say, that you are choosing your right to remain silent. And if this is one scenario that we've heard business owners and employers talk about, what if an ICE officer comes into your places of business and says, I saw this person named on the warrant go through that door, and I want you to open that door for me to let me do my job and arrest this person. You don't have to do that. You do not have to open the door. You do not have to help the ICE officer do their job in executing this warrant. However, if the ICE officer says, you open that door or I am breaking down that door, then you have to choose what is going to be in your business's best interest. But again, what are you going to say? I object. Okay. Now, a couple other things about this, about judicial warrants. You want to make sure that the date is still valid, because if it was issued to the ICE officer some time ago, then there's a time limit on it. If the time limit has expired, you can hand it back to the ICE officer and say, this is no longer valid. And then there will be an offense that's described here. Again, whatever the reason is that the ICE officer convinced the judge that they should issue a warrant. Make a copy. Make a copy of whatever documentation is issued to you. Best to do it in a photocopier, if possible. I'll tell you why. Again, slows the process down. If you don't have time to do it in a photocopier, you can take a picture with your phone. But you want to keep a record of what's happening. Things happen pretty quickly. Just try and keep that in mind to keep a record of whatever is happening. Now, here's a different type of judicial warrant. This is a search and seizure warrant. This is quite similar. It's again issued by a judge or a magistrate judge. But there are a few other things that you need to take a look at here to make sure, because if you get a search warrant, I want you to take it very seriously. The reason is that, again, this is going to be to an authorized law enforcement officer. It's not going to be addressed to you, but it might have your address on here. And search warrants will have an attachment to them. It will tell the officer what the court thinks it's okay for them to look for or take And if you have a search warrant that is issued to you or your business, the reason you need to take it seriously is because you probably are under some investigation for violation of some federal law. So to some extent, search warrant is much more serious than an arrest warrant, even though we think about we hear much more about a search warrant. Now, you want to make sure that you're reviewing the scope. You do not want to consent to going beyond the scope at all. And you definitely want to contact your attorney because you want to know what you should be prepared for in terms of any potential defense and any potential strategy if you are under investigation. Now, so when ICE comes, where can they go? You probably heard a lot of talk about about ICE being allowed into public areas and not into private or restricted areas. If you have a type of business that has a front reception desk, yes, they may enter the reception desk, the reception area. They may look around, and if they see anything that they believe is evidence that they would want, they can take anything that is in, as we call it, public view. However, they are not allowed to wander around in private areas or restricted areas. I rather prefer the term restricted as opposed to private because restricted suggests that there is some, like a key card or a code or a request for permission to go into that area. And you can mark or you put signage up to designate what are those restricted areas. What are the public areas where they could go? The building lobby, reception area, parking lot, any place that's open to the public for shopping. Any sort of waiting rooms, for example, in a healthcare facility, any sort of restricted hallways. At restrooms, maybe if they're open, if you don't need a key to get in there, those also are public areas. And one I want to point out here is a parking lot because it might be that if ICE comes and they are looking for a particular individual, they might just go wait them out in the parking lot, thinking that eventually they were going to leave. They can do that. Now this is a time when you want to probably videotape what's going on, see if you can get a recorded record of how long they're staying, who they are, how many people, if they who they seem to be interested in, who they are talking to. You can also make a statement to individuals to remind them that they have a right to remain silent. You can remind your own employees, you can remind anyone that is in your facility that they have a right to remain silent. And then again, the restricted or private areas where they cannot enter without a judicial warrant, or, and I want to remind you again, without your consent, without the business or employer consent. Actually, without anybody's consent. If you have a customer who asks, hey, can I go back here? And ICE is there and they say, yeah, sure, I guess you can, that is consent. So you want to make sure to not consent beyond what you, not consent at all, only allow access to ICE to the extent necessary that you feel is necessary under the law. Now, I want to tell you about some recent examples of ICE worksite encounters. And with these examples, I'm going to kind of highlight some of the issues that we've already gone over. The first one is a very recent one, and that was in Northwest Washington State. There was an ICE raid. This is one we can actually call a raid on a roofing company, Mount Baker Roofing. It was beginning of March. And you see this photo here? Well, as I understand it, it was pretty heavy-handed, and there was technical equipment. There were helicopters flying above. There were law enforcement agencies, ICE for sure. We're not sure who all else. But guess what? There wasn't judicial warrant. There was no judicial warrant for this ICE raid. According to the reports, there was something that was called a federal warrant. And I can almost guarantee you that that was an administrative warrant that Department of Homeland Security or ICE wrote out themselves in order to come onto the property. They really intimidated the folks there, the employers there. Now, you want to think about what might trigger one of these ICE raids. And this one occurred after there was an OSHA fine about a month earlier. OSHA, the Occupational Safety and Health Administration, it was actually the state agency, the corollary to the federal OSHA law, the Washington State OSHA equivalent. And about a year ago, before that, there were some worker complaints about some of the facilities, bathroom facilities, and that sort of a thing. So this is one thing that might prompt an ICE visit or a raid if you have any other compliance issues going on. Okay, here's a second one. Abby's Bakery, a donut shop. It was a bakery for Hispanic baked goods. Just a little bakery in Texas, February of this year. And ICE came in and arrested some of the employees there for lack of immigration authorization. This is what I want you to remember about Abby's Bakery. Again, they had no warrant, but afterwards they filed a federal criminal harboring complaint against the owners. Criminal complaint against the owners. And some of the employees said, oh yeah, they knew I was here working without authorization. So I think that's something you need to be aware of. I mean, we all want to treat our employees well, but you need to, employers must employ only authorized workers in the United States. And we have not yet seen very many complaints against businesses for harboring of unauthorized workers, but it's coming. It is coming fairly soon. All right, the third one was a taco truck in Memphis, Tennessee in February of this year again. And there's a video of that. If you want to see these videos later on, I can send them to you. I'm going to show you one of them, but if you want to get more information about that, they're pretty easy to Google, but we can send it to you if you want to see it. In this one, surveillance video showed that two guys came into the kitchen, the working area of a taco truck. No identification on them, just, wearing hoodies and some masks. And they ask a few questions to the three guys who are working there, and they take them off. What's the common scenario here? Also, no warrant. And there was, it's hard. It's very hard to stand up to these big guys who are coming in saying, I know you're not here legally, and making you put your hands behind your back and taking you off the truck. All right, the fourth one is Ocean Seafood in Newark, New Jersey in January, where there were employees detained, including one U.S. citizen, a military veteran, who was asked to show his ID, and they questioned him about it. He was later released, but this kind of goes to show that there is going to be what ICE is starting to call collateral arrests of individuals. Okay, so now we are going to show you a quick little video of this fourth example.
And Diane, while you're pulling up the video, we just have a few questions, just 3 questions the folks wanted to ask you.
Okay.
And I know you kind of addressed it a little bit earlier, but thought it would be good to just bring those questions out again. But the first question is, when presented with admin warrant that's not judicial, you have the right to silence as well. Is that right?
Correct. Yes,
Okay.
that is correct.
And can you respond by saying, I'm not answering any questions like that? Is that a perfectly good statement?
Yes.
Okay.
Yes. Now, one of my colleagues and I did a presentation a while ago, and another question that comes up is, do I have to show my ID? You can also assert the right to remain silent in not presenting your ID. You shouldn't be required to have to present your ID. You can maintain the right to remain silent. But as my colleague said, if this is my uncle in Tacoma who's asked to present his ID, I'm probably going to tell him, you might want to make the choice to present your ID. So sometimes it does take a little bit of a judgment call.
Great. Second question, can a search warrant be issued for a database? This person who's asking the question, they have data that doesn't show status, but from those that take their online classes.
Yes, yes. And I have been involved in a case where a federal search warrant was issued to a client of mine. And I'll tell you what, if there is a federal search warrant, there's really, you can try to help limit them to the scope. And you definitely want to take a copy of the search warrant, but they have forensic equipment, technology, where they are just going to swoop in. They can come in and they can do what's called imaging your data, taking copies of it usually without having to do things like pick up your laptops and take them away. So yes, but a search warrant these days, very likely, if there's an investigation of a business, might involve collecting some of your data, your technology information and data.
Great. Last question is, if ICE comes to our restricted business door, do I have to open the door to hear them out?
You do not. In fact, don't open the door. In fact, there's a concept called not crossing the threshold. So if ICE comes to the door and they say, I have a warrant, if they put the warrant up to the window right beside the door, and you can see, in fact, that it lists your name on it, you do not have to open the door. If you do open the door, and if you put one part of your body across the threshold of the door, then that's like giving consent. They can literally grab you and take you if you cross the threshold.
Great. And one more, sorry, I meant not great, but the situation I'm saying, one more question I wanted to, there's asking, can they arrest you if you refuse to show ID even though you are a US citizen?
When the question is, can they do it? I mean, they can do it, but you could fight it later on. So that's really the main issue. But one thing to think about is that ICE has a mandate right now to arrest at least 1,500 people per day. And they would like to grab as many as they can at one time. It doesn't make any sense for them wasting time on individuals who they have no business arresting or detaining or taking into custody. So you may be able to just politely wait them out, or, respectfully, or, wait them out. Just say, I know you're busy. You really don't want to waste your time with me. I've done nothing wrong. So the short answer to the question is yes, they could, but they try to convince them that it doesn't do them any good to arrest you. And same if they're in your business or in your place of employment. If they come in and you say, look, we know you're busy, we know you've got a job to do, we haven't done anything wrong. We don't want you to waste your time, go catch the bad guys, sort of a thing.
Thank you, Diane. And then just want to let you know it's 2:53, so almost time, a little bit over our next section, but I know you're going to show the video now, right?
Yes.
Yes, great.
Okay, so.
The Trump administration promised mass deportations, and while we haven't seen that yet, we are seeing a larger crackdown on illegal immigration, including a raid at the Ocean Seafood Depot in Newark. That's where several people were taken into custody. Let's get right to Good Day's Briella Tomasetti. She is live outside that fish market with more. Briella, good morning.
Good morning, Deshani. A lot of people wondering what exactly happened here, and Mayor Ross Baraka plans to update the public later this morning. Immigration advocates and local elected officials will be among those in attendance. Baraka said this was a warrantless raid that violated the Fourth Amendment. Immigration advocates in Newark allege that federal agents descended on Ocean Seafood Depot here on Adams Street at around 11:30 yesterday morning without a warrant and demanded to see workers' documents. Officials initially rounded up a total of 8 people, 4 women, all of whom were mothers, and 4 men. According to Rafael Chavez with New Labor, a New Jersey-based organization that represents immigrant workers, all 4 women showed their IDs. He says ICE agents took their fingerprints and gave them slips to appear in court next month. 3 of the men allegedly had no documentation and were detained. The 4th was an American citizen and released. Chavez giving us his account of what happened.
7 members of ICE come out, and I see they went to different cars, and it looked like a regular car. So we need to educate also the managers or the owners of the small business how can they are and how can defend their workers in the workplace.
Mayor Ross Baraka put out a statement in response to the raid saying U.S. Immigration and Customs Enforcement agents raided a local establishment in the city of Newark, detaining undocumented residents as well as citizens without producing a warrant. One of the detainees is a U.S. military veteran who suffered the indignity of having the legitimacy of his military documentation questioned. When it comes to the promise of mass deportations, President Trump says he'll focus on violent criminals first, like sex offenders, gang members, and drug cartels. But Border Czar Tom Homan stressed that anyone living here illegally could very well get a visit from federal agents. ICE released an update yesterday saying that so far the Trump administration has arrested 500.
Okay, so I think you probably get the sense there of what is happening. And as I pointed out, business owners need to be aware of how to defend themselves and to know what to ask for. So let's see, we're going to just kind of wrap up this section quickly. Back here, okay. Okay, so in summary, if ICE shows up, contact your counsel. You've already got your plan in place, so you're going to implement your plan, limit the action to only the scope of the judicial warrant. You're not going to interfere with what's going on, but you're not going to help. And you're going to record and write down what happened because it's going to help you process for yourself later on, but also maybe defend against any actions that occurred. And this is a checklist we can send out to you later on. We've gone over all of these issues to check to see who they are, what they look like, whether they're armed, what documentation they have, whether they're threatening or unprofessional, and then to find out what's happening next, what kind of follow-up you're going to need to do if somebody is taken into custody, where they went, and how you can possibly assist them. And then I think we've gone over most of this already, do's and don'ts. Make sure you do read the warrant, that it's a judicial warrant, make a copy, keep a record, don't consent to areas of search beyond the public areas, do not lie, don't give unnecessary information, and don't interfere with the judicial warrant's directions. All right, now we are going to focus on handling Form I-9 audits. So again, the agency that is charged with these I-9 audits to make sure you're complying with the requirements to verify employment eligibility is Homeland Security Investigations, HSI, not ICE. Actually, ICE does become involved if after HSI reviews the forms and they're going to impose a penalty, then ICE will be the one who you'll have to deal with in terms of addressing any sort of penalty. There is a new updated version of the I-9 form that recently was issued. It's actually backdated to January 20th, 2025. And it has a few changes, really just a few changes. The former version of the form asked for information about non-citizens. It now says alien. This version here shows that non-citizen, but it has been changed to alien. And there aren't too many other changes to the form, but you do need to start using the new version of the form for all of your new hires and any sort of updates. Now, one reason I want you to really focus on your I-9s is two reasons. One is that I-9 audits are becoming a bit of a cash cow for Department of Homeland Security because they try to extract the maximum penalties possible. The other reason is that it might prompt a notice that tells you who the agency thinks is not authorized to work in the United States. And this is how an I-9 audit would play out. You would have a visit from somebody from HSI. They will have identification. Most likely it is an in-person visit. Sometimes they will send it to you by mail, but these days they kind of want to confront the business owner employer face to face to hand it to them. And it will tell you that you have 3 business days to deliver back to them all of your I-9 forms. It used to be that HSI was somewhat lenient in terms of giving extra time, but we've been learning that since around last summer, they have pretty much stopped that leniency. They will tell you, no, we need those forms within 3 business days. It used to be that there were certain holidays of the year where it seemed like ICE would want to do all their I-9 audits around the 4th of July or Thanksgiving. And it was like, oh no, I've got to, pull all these together around the holidays. Now it's almost as though we'd prefer to have the I-9 audits over the holidays because it can give you a little more time before you get to that 3 business days. Still, you can always ask for a little more time. Maybe there will be a lenient HSI officer. Now, here is a big change that I want you to be aware of, and that is in the notice of inspection. It is going to say that you may not make any changes to your I-9 forms after the date of the notice of inspection. Now, the reason this is a big change is that we have always advised our clients that as soon as you get an I-9 audit, if you haven't already done an internal audit to make sure things are in good shape, you want to do it at that time. But if ICE is now, or HSI now is saying you can't make any changes, then a reason is that they are going to put you in the position of having more errors on your I-9 forms. And if 50% of the I-9 forms that you turn over to ICE have errors on them, and they are going to impose any penalties at all, they are going to impose the maximum penalty, which at this point in time is $2,861. And this is just for paperwork violations. And that can add up pretty quickly. In the past year or so, I've handled a couple of I-9 audits where they both were around $500,000. One of them was for paperwork violations only. So again, if you're not given the opportunity to make any changes, then it's going to be easier for them to say, more than half of your forms had errors. We've got to impose the highest amount of penalty on these forms. Now, they do have discretion not to do that, but that has just been the policy that they have been implementing. And here are a couple of types of errors that you really want to pay attention to. There are technical errors and there are substantive errors. You're supposed to be able to correct any technical errors, things like, oh, I forgot to put middle name on, or it says obviously the state of Washington, but the state is missing. And then there are substantive errors that HSI considers to be more serious. That is, that they might relate to the employer not really checking to see if the individual is authorized to work in the United States, maybe turning a blind eye. And those would be like on this what we call the checkbox section here. on section 1, where the individual is supposed to check whether they are a U.S. citizen or a permanent resident or not a citizen of the United States. So the idea is that if none of those boxes are checked, then there is a presumption, oh, they must have had something to hide and they must be not actually be a U.S. citizen, or they must be not authorized to work in the United States, which is why they didn't check any of these boxes. So the failure to check the boxes is considered a substantive error. There are other errors that technically you could fix that. You could hand the form back to the individual and say, you forgot to check this box, go ahead and check it. But there are certain errors that you can't fix. For example, I'm sure many of you are aware that the I-9 form needs to be completed within 3 business days after the date of hire. And you have to fill in that section. If it is not completed within 3 business days and you fill in a later date, you really can't fix that later on. So that is deemed to be a substantive error. And the idea there is that ICE thinks, oh, maybe the employee is not really presenting valid documentation and the employer is giving them more time to come up with fake documents. So now back to the point about the notice of inspection saying you cannot correct errors after the date of the notice. Take your time, take whatever time you can to correct those errors. We haven't seen this play out yet. We don't know what ICE is going to do about it, but I can tell you, if I have a client who received a notice of inspection and they went ahead and made the corrections before they turned those documents over to HSI, I think we've got a pretty defensible position that there should not be penalties for those sort of error corrections. Now, if you haven't done an internal audit, I would recommend that to each and every one of you. Each and every one of you. Pull out all of your I-9 forms, take a look, see what there is that you can correct on them before you have a chance, before HSI has an opportunity to give you a notice of inspection, because we will be seeing many, many more I-9 audits. A couple more points to make sure you are consistent in the corrections that you make and also in completing the I-9 forms. One improvement to the I-9 process over the past couple of years is that I feel like there is now better information available from Department of Homeland Security on a website called I-9 Central about documentation to accept, to complete the Section 2 part of the I-9 form and to do it correctly. One thing that I still am seeing a fair bit, though, is what we call over-documentation in a couple of different areas. So you see down here towards those last 3 bullet points, I think there's still a bit of misunderstanding about when employers should insist on new documents if a document that was initially presented expires. But here are 3 types of documents. They have to be valid and unexpired when the individual presents them at the time of hire. But if they expire, do not ask for new documents. And that would be the U.S. passport, green card, and any sort of driver's license. And the main problem here is the green card. If your employee's green card expires and you say, I need you to present a renewed or updated green card, or I'm going to have to terminate you, then that becomes an issue of not only over documentation, but discrimination. So those are a few points to take a look at when you're doing your own internal audit, when you're making sure that your I-9 forms are up to date. One other issue that is coming up, and this is actually coming up in one of the cases I'm handling, is the electronic signature procedure. There is very little guidance from HSI or ICE or USCIS. All of those folks have some guidance available on the I-9 process, but there's very little guidance about how to satisfy the electronic signature procedure. And during COVID, there was a fair bit of flexibility about reviewing documents remotely to satisfy the I-9 requirements. But HSI is taking the position that they have some sort of expectation about electronic signatures, which appears nowhere in the law or nowhere in the guidance. We're trying to figure it out exactly what they are expecting. But if you have any sort of additional documentation showing when the electronic signature was fixed to the form, any dates of any changes, any sort of metadata, or any sort of email password attached to show how that electronic signature was affixed, then you'll probably be okay. You can contact me later on as we're weaving our way through litigation against on these I-9 issues to see if we can figure out exactly what they expect. And more importantly, if they would just tell the public what the expectation are. Now, I imagine some of you use E-Verify, which is the federal government system that provides for checking on a government database, comparing the documentation the employee presents, for example, U.S. passport, or maybe an employment authorization document, an EAD card showing they have authorization to work in the United States. Those types of documents have information available in a government database. You can check to make sure that the individual is authorized to work. And I can tell you with my clients who are using E-Verify, and when I've been involved in I-9 audits with them, I have found that there are many, many fewer errors on the I-9 forms by use of E-Verify. So I would recommend considering using E-Verify if you don't already use it. Okay. Oh, you know what? Questions, yes. Do we have any questions on I-9 audits?
Yes, we have several questions. I think some of them you have already answered, but I'm just gonna say it again. So first question is Washington State required to do E-Verify? And what if we did not use E-Verify as that was a choice when we hired employees?
Washington State does not require E-Verify. Some states do, but Washington State does not. And what was the second part of the question? If you
if it was if they didn't use E-Verify when they hired their employees.
Okay, so when you become an E-Verify employer, then you use E-Verify only for all new hires or any employees who are working on any federal contracts where those contracts require you to use E-Verify. You do not go back and run E-Verify through, you do not run current employees through the E-Verify process. But if you have a new hire and for some reason E-Verify wasn't utilized when they were onboarded, then you do it now. Just go ahead and go back and do it. There's a little bit of an explanation that you click on in the E-Verify system to say kind of like, oops, I missed doing this when we onboarded the person. And then if you did have an I-9 audit, then that would be a violation. But if you're doing any sort of internal I-9 audit, you can keep a record of the fact that you did the audit, you found some deficiencies, you figured out what was wrong, and you're correcting them going forward. And then that can go, that can be evidence for mitigation of penalties. So that's how you would address that type of situation.
Okay. Second question is, can the company notify its employees that there will be an inspection?
Yes, the company can notify the employees. In California and Oregon, it's required to notify the employees if there is an I-9 audit. Outside of California and Oregon, I probably would not recommend notifying the employees because it may raise a false sense of concern or alarm. But if you think there might be some reason for notifying the employees, then you would want to assess the cost benefit analysis of doing so.
Third question, I heard that one can file for an extension 1 week on that 3 business days deadline to deliver I-9. Is that true?
You definitely can ask. There's no rule or provision saying that there is a potential extension. You can always ask, and it really kind of depends on the individual HSI officer you're dealing with as to whether they agreed to it or not. Let's say you ask for it and they say no, and you don't provide the I-9s on time, then even so, there's not a regulation that says that is an added penalty. It's not going to get any worse than paying the maximum for each particular I-9 form. So and then you can maybe explain it later on. You know, I'm sorry, I couldn't get them to you on time for this reason or that reason. So in fact, the regulation says that the notice of inspection has to give you at least 3 business days, but typically they give you only 3 business days. So that may be an argument for actually requesting more time.
The next question is, so when a business receives a request to have these documents, the forms, can we predict that they might arrive in person at some point?
No, I wouldn't say so. We haven't really seen that occurring. That is, having any sort of raid happen after you have an I-9 audit. It might start happening, but that hasn't been a standard procedure up to this time. In fact, a colleague and I were sharing information about that Mount Baker roofing raid and wondering if there had been an I-9 audit, and apparently there wasn't. I mean, it is possible, but we might start seeing it, but it's not always going to be the case.
Next question is, can they ask to see I-9 forms of employees that no longer work in the business?
Yes, in fact, the rule is that you must retain your I-9 forms for the longer of 1 year after termination or 3 years after hire. So you always are going to produce all I-9 forms for current employees, but you might have an obligation under that 3 or 1 rule to present I-9 forms for terminated employees as well.
Okay, the next question is a little bit longer. Well, what if the I-9 was filled out before you took over this position? There people have been there for a long time, and the admin that filled out no longer are with the company. Should you fill out a new one?
No, you wouldn't fill out a new I-9 form just for that reason. And one of the main reasons not to do a whole new I-9 form is because you would need to ask the employee to present the documents that are now currently valid in order to show that they're authorized to work. So for example, let's say you had, there was a US citizen who was hired 10 years ago, and at that time they presented their passport. The passport was valid at the time, and now you say, okay, sorry, I need you to fill out a new I-9 form, and then they haven't traveled outside the United States, their passport no longer is valid. They might need to go get a new passport, and which might take some time. So there can be some practical implications of unnecessarily asking employees to fill out a new I-9 form. But the other reason that you don't need that you can go ahead and do that internal audit and make the corrections is that it's kind of expected. And the way you do the corrections is that you put the correct information on the form, and then you're always going to initial and date next to it, whoever makes that correction. If you end up handing the I-9 form back to your employee to make the correction, then they're going to initial and date next to the correction. If anybody in HR makes the correction, then they're going to initial and date next to it. And that's fine. That's not a problem. And then usually it's best to attach a memo to each I-9 form explaining the correction.
Okay, last question. And so do folks need to photocopy the documents submitted to the employers? I think there was a question of whether the employer should photocopy them or yeah, I think that was the question. Yeah.
Okay, so if you are using E-Verify, there is a requirement to photocopy certain documents. And you want to pay attention to those rules. Not every single document, but certain documents would need to have a photocopy attached to the E-Verify confirmation page, which is attached to the I-9. But aside from that, you will want to establish your own policy about whether to photocopy documents. And my recommendation usually is to photocopy the documents, but not for the purpose of keeping with them with the I-9 form. Because if you do, then you need to turn over all the documents kept with the I-9 form. And if you have done it inconsistently, then that is going to be an issue for your company, that you've been inconsistent. But you can copy those documents and then keep them in a separate folder for a different purpose, which would be have a policy that you're keeping these documents for the benefit of the employee in case they lose them, need to look at them, or whatever purpose that the employee might need them to file for an extension. And then that way you can, if an I-9 audit comes up, you can refer to those documents kept in a separate file, but it's not required to turn them over to HSI when you turn over the I-9 forms. And the issue there is that you never know. ICE or HSI might see something on one of the documents that you retain saying you never should have kept this document. But if they're only looking at the I-9 forms themselves, then they can only base the information on what was recorded on the I-9 form.
Thank you, Diane. There are more questions, but we're gonna hold them off till after you're done with your presentation. And then because some of them were related to your first section, so we'll wait till then.
Okay, sounds good. Okay. How's everybody doing? Anybody need a stretch? I'm going to take a little stretch here. Okay, there we go. All right. Okay, so Social Security no match letter we're going to be able to go through relatively quickly. And one of the reasons is that that there so far we've not been hearing about Social Security no match letters being issued on a wide scale basis recently. But I want to tell you a little bit of background information about why Social Security no match letters are issued and maybe dispel some myths about them. The no match letters are not issued for the purpose of finding out who's not authorized to work in the United States. In fact, the letters are actually called employer correction request notice. And the reason that they are issued is because the Social Security Administration has what we call this suspense fund, with all of these uncredited wages they've been collecting that you as employers have to withhold and submit to the Social Security Administration. And look how much money is in this fund right now, $1.2 trillion. This is in our government's treasury, in this suspense fund that they can't match up. So they really want to be able to match up these funds so that, you know, people are getting credit for their contributions. And they've got these discrepancies where it seems to have come from an individual employee that provided by the employer, and then maybe there's a duplication of numbers or typos or anything along those lines. So there really are, the reason is to correct the information. And I've recently had a question to me, how soon shall I send an employee a termination notice after I get a Social Security no match letter? Never, never, never. In fact, right in the letter itself, it says to you, whoever it's addressed to, the employer it's addressed to, you should not use this letter to take any adverse action against an employee, such as laying off, suspending, firing, or discrimination against the individual, just because his or her SSN or name does not match our records, okay? Do not take adverse action such as laying off or firing just because you get a no match letter. You get a hold of the employee and say, hey, the records don't match. Can you take a look at it? Let me know if you can help us figure it out. It might make sense for them to actually go to the Social Security Administration office, because I know if you or I found out that they were not crediting our Social Security account with money that had been that was held for us, and we would want to fix it. But there's not even a requirement to tell the employee to go and try and fix it. It makes sense to do so. And if you can resolve the discrepancy, there's a form to send to the Social Security Administration so they can correct it in their records. But other than that, there's no teeth in a Social Security no match letter. A decade or more ago, there was an effort to say you have to do various different things within 90 days, but that never was implemented. So if you get a Social Security no match letter, do try and resolve it. Who knows? We might see that Department of Homeland Security will talk Social Security into handing over information, like they're trying to talk the IRS into handing over information. But so far, that hasn't happened. So Social Security no match letters are, pay attention, but don't stress too much over them. If we have questions about that, I think we'll go ahead and hold those to the end as well. So now we're going to kind of talk about some of the best practices for businesses and employees. And I want to talk about one that I know that's not listed here, but I know folks are interested in, and that is the termination of TPS, temporary protected status, for certain countries. So temporary protected status is TPS is something that can and has been made available on a country by country basis for various different administrations when there is turmoil in the home country that makes it extremely difficult for individuals, citizens of that country, to return home. In the most recent TPS countries that we have been hearing about are Venezuela, Haiti, Cuba, and Nicaragua. Venezuela was assigned TPS status in 2022, I believe, and Cuba, Nicaragua, and Haiti after that. And so TPS is available on a 2-year basis. Again, you have to have been in the United States when TPS was designated for your home country. You can't claim TPS from outside the United States. And when you have TPS, you also have the ability to have employment authorization in the United States. So it was actually the Biden administration that decided to end TPS for the 4 countries, Venezuela, Haiti, Nicaragua, and Cuba. But the Biden administration deciding to end it was going to allow it to play out the current validity period, which was to October 2026. And now the Trump administration came in, decided to what was called cancel TPS for those 4 countries, which would have had the impact for Venezuelans in particular to no longer have had those who have TPS no longer to have had the right to remain in the United States past April 3rd. And then they were supposed to leave by April 7th, just yesterday. However, there was litigation that was filed in a couple of different federal courts. And in the Northern District of California, a judge there put a temporary restraining order, a hold on the Trump administration's cancellation of TPS for Venezuela. There also have been a couple of cases filed for Haitians who have TPS. And there was one in Boston where the judge decided to just do hands off on even ruling on that case, saying that the Northern District of California case should cover the Haitians as well, not that is, in the Northern District of California case, the judge there allowed more time to include the Haitians as members, as plaintiffs in the Venezuela case. So we're waiting to see what's going to happen with that. And I know many of you business owners and employers rely on those folks who have TPS. They're, good and valued employees for your businesses, and you're wondering what to do about the fact that they might not be able to continue working for you. So that kind of brings us back to what employers can do for any of their employees where they would like to provide some sort of immigration assistance or sponsorship. And you really do need to assess it on a case-by-case basis. To some extent, there might be some buckets of opportunities or remedies, as we call it. For example, political asylum is one type of remedy that might be available when the individual has a fear of returning to their home country based on a fear of harm from the government, based on their political beliefs, their gender, their being a member of a social group, their religion. So if an individual believes that they have a claim to political asylum, then an opportunity or an option would be to file a political asylum application, get it on file. And once an individual has some sort of basis for remaining in the United States, they really should not be subject to removal actions. I know. We've been seeing some contrary actions where individuals who have some sort of basis for remaining in the United States, nevertheless, are still subject to removal actions. But at this point in time, we need to kind of brainstorm and see what all of the options are. So another option might be family-based sponsorship, particularly marriage to a U.S. citizen. Now, if an individual already is married to a U.S. citizen, then the U.S. citizen can file a petition for their non-citizen spouse to remain here. Other family members, immediate family members, parents and children can be sponsored by U.S. citizens. There may also be sponsorship available from green card holders or even individuals who have some sort of employment-based category. And those are what we kind of think of as the ABCs, all of the different alphabetical categories under the immigration status. They might be just a visitor in the United States. They might be an employee under H-1B status. They might be a foreign student under F-1 status. And if they're a foreign graduate, they might have employment authorization, what we call optional practical training under OPT. So it takes it really does take a kind of a case-by-case assessment of what the options are for any particular individual. But for you as employers, you want to think about what's in the best interest of your business, do the best you can for your employees. Think about the issues that came up in the 4 examples of those raids that we saw. One of your best defenses is in treating your employees well. We have heard time and time again that I-9 audits often are prompted by whistleblowers. If you have any recently terminated personnel that have an axe to grind, they really might go to ICE and make a statement that you are hiring somebody who's not authorized to be in the United States. I heard this happen just in the last couple of months to a pizza parlor in Seattle where they had an I-9 audit. And I asked them, you have any sense of why they might have given you an audit? Anything come up? And they said, yeah, we know exactly. We terminated a manager And the manager said on their way out that they were going to report to ICE. So it used to be that those kinds of reports did not so quickly prompt a response from ICE, but now that one happened about 2 weeks after the termination. So yeah, good defense is treating your property, treating your personnel well, and making sure that you are not in violation of OSHA regulations or other regulations where ICE might gain access to that information, decide you might be a target that helps them get to their 1,500 arrest per day. So if ICE or any other enforcement officer comes to your place of employment, here are some of the best practices. You state your objection. Again, you might want to practice this just so you can feel comfortable saying, I object, I feel threatened. I'm only doing this because I feel you are unnecessarily threatening me. State your objection. You want to follow them around. Honestly, you can follow around ICE with your video and record what is happening. They might say, you are interfering with my investigation. You are interfering with me. If you've got your phone and you're recording it, take one step back and say, I'm not interfering. You want to keep a record. You're not going to remember what happened after. You're not going to remember everything. You can remind your folks of the right to remain silent. If ICE takes anybody into custody, try to find out where they're going. If they take any of your records, documents, anything that they are taking as evidence, they should be leaving an inventory notice. If they're not, try and make the best record you can as to what happens. And as we said right at the beginning, they can be very intimidating. They might say, you have to cooperate with me, or things are not going to go well for you. Then you can ask, what do you mean by that? You know, that's probably going to catch them off guard. Who knows if they will respond at all. One scenario I want to point out to you is that there was a recent incident where I showed up at a school, as we understand it, to arrest a school nurse. There were folks who swarmed around them, videotaping them, taping them with their phones saying, where's your warrant? Where's your warrant? Where's your warrant? Where's your warrant? And then finally, ICE just left. Again, there are not a ton of judges or federal judges, magistrate judges who are issuing warrants to ICE. Who knows whether they're even asking for them, but they're not taking the effort to explain probable cause for any sort of what they're claiming are violations of federal law. So let me put it back on this slide for you to take a look at as we go over the additional questions that you might have.
Thank you so much, Diane. I have several questions for you. The first question is, for Social Security no-match letters, how does this work for independent contractors like app-based drivers? If the ER use third-party verification companies and then will kick the driver off the app base on Social Security mismatch. Any thoughts on how drivers could or should respond to these?
Let's see. So it would be the third party, whoever is the employer would be the one who receives a Social Security no match letter. And if that employer takes the step of giving a copy to the driver or employee, then the employee should just point out that statement on there that says, don't take any discriminatory action based on this alone. I haven't heard of that occurring. I'm sorry if folks are experiencing that. There may be some employers who still misunderstand what the Social Security no match letter means. And so if you have any opportunity to point that out to them, that it's not an indication of lack of authorization, then you know, maybe that will resonate with them.
The second question is at what point should you renew an expired document?
The general rule of thumb is to have a tickler system for reminder of expirations coming up 6 months down the road, because there are certain renewal or extension applications that can be filed 6 months in advance. Some of them are 180 days. We didn't talk about DACA. DACA is one category where you have employment authorization that goes along with the DACA category. And the general rule is to file for the renewal 180 days in advance, but last year we were filing whenever we were 12 months within the expiration. And because, well, it was before January 20th, and we had some pretty quick approvals. But you don't want to wait till the last minute. You never want to wait till the last minute when a document is expiring. And so that's why the rule of thumb is 6 months, because even if you file something too soon and the Immigration Service, USCIS, rejects it, saying this is too early, then you still have time. But waiting until a little closer to the expiration time, you might run out of time.
Next question is it's about green card. So if it expired, are we not able to request a new one? What if it did expire and never got renewed?
Green cards, you can file for an extension 6 months in advance. And even if it's already expired and you didn't yet renew it, do it now, because an individual who has a green card has permanent residence status, and that permanent residency does not go away just by virtue of the green card expiring. That's one of the reasons that employers are not to insist on renewal of a green card in order to satisfy I-9 requirements. And there's the immigration, USCIS will process your green card if you file even after it expired. So there's a way to file online. You can create an online account and submit an online application to renew your green card. We found that the online applications tend to be processed faster than mail-in paper applications. If you have something that you want to explain when you're filing your green card renewal, then that tends to work better by filing it on paper, because you can have that written explanation. But otherwise, you can go ahead and file online. Another benefit of filing online is you get a receipt notice as soon as you submit the renewal application. And then that's something that you can carry with you as evidence that you have the right to remain in the United States. With many different agencies, maybe local police and sheriffs being involved in enforcement of immigration law, they don't understand immigration law. And so if an individual happens to have an expired green card in their possession, they might jump to the conclusion that the individual does not have a right to remain in the United States, but they do. So, just to help avoid that sort of misconception, it's going to be better to at least have your green card renewal in process, even if it's already expired.
Next question is, if you don't fill out a new I-9 form for a lost form, what level of documentation do you need to do?
Did you say I-9?
Yeah, it says if you don't fill out a new I-9, what level of documentation do you need to do?
Oh, okay.
Or if you lost your I-9.
Lost an I-9? You mean an employer doesn't have an I-9 form for an individual?
Yeah, I think that's what the question is. If there's what the question it seems to entail is if there's a lost form for an employee, and you don't fill out an I-9, what do you need to do?
Okay, so it sounds like an employer is doing an I-9, internal I-9 audit, and they realize that they're missing some I-9 forms for one or more employees. You do need to complete it at the time. And when you complete it, you need to ask them for documentation that is valid at the time that you complete it. You're going to need to put in the date of hire, the actual date of hire, even if it was months or years ago. And you're going to need to put in the actual date of the completion of the employer portion, which is section 2 of the I-9 form. And that is definitely going to be more than 3 days after the date of hire, which is putting you out of compliance. But that's when you would want to have your memo accompanying that I-9 saying, we did an internal I-9 audit. We found missing I-9 forms. This is what we did to rectify that, acknowledging that we didn't do it within 3 days of the date of hire. This is how we're going to avoid that sort of scenario going forward. So that again may be evidence that would help you to get mitigation in case there were penalties for the I-9 audit.
Next question. Will you incur penalties for corrections with more recent date? And I think this is with, it sounds like it's for I-9.
It depends on the penalty. I mean, it depends on the correction. So if it's a recent correction that does, that only fills in some of that, what we were talking about, technical error information, then you would not incur a penalty. And it doesn't matter too much whether it's a recent correction or an older correction. The point is, the main point is that it's best to have your I-9s in as good a shape as possible, and not have any errors on them to the extent you can avoid that.
The next question, I think is kind of similar, is for the sake of safety and compliance, should we update all I-9s for current employees? I don't know if you were able to hear that, Diane. Oh, okay. I think. Oh, I think we might have lost Diane for a little bit. So we'll wait for we'll wait for a bit till she comes back on. Okay, folks, I'm so sorry for the technical difficulties. I think Diane is going to try to come back on. But in the meantime, what I wanted to say is thank you everybody for attending today's training. I hope it was helpful and informative for you all. It will be really great if Diana does come back. We can do a little send a reaction, the clapping hands for her when she gets back on. But so I really appreciate if we can do that. But for after this training, we will send out recording and handouts and presentation slides. And so please look for an email from us. It'll be a follow-up email. It'll provide the links to the presentation, to the recording, and also a handout. We will have handout that's translated, and so you can share to folks in your communities and your network. And if you have any additional questions, you can feel free to contact me I'll quickly share my contact information slide in a bit, but if you have any other questions, especially with Office of Immigrant and Refugee Affairs or Office of Economic Development, we're still here and so we'd be happy to answer any questions about that. And you can also contact us individually. You can contact Michael and Kat or me if you have any questions that you would like to ask as well. So I am presenting my little slide with my contact information. Hopefully folks can see this. Great. But yeah, if you have any questions, then please continue to keep putting them in the chat. And then we'll see if we're able to have Diane join us for a bit, but otherwise, thank you so much for attending this training. And like I said, I hope it was really helpful for you all.